the people who receive the dowry will nurture the relationships of these two couples. Because by the time one of them will betray the man, or if their marriages will not succeed, then those who receive those who receive dowries is obligated really to return it. No? So if ever the man is really very irresponsible, then the parents can just give a little token and will be sent back home. And the woman now will be having the arranged marriage. Then that dowry of that second marriage will be given back to the man. So for us now, it seems that if the woman is not married to a man, it's like, no, it's not acceptable. But to the Manovo, for example, it is, if the woman would choose another man and he will abandon the first, if he has a partner, then the man cannot refuse. Because to us, he said, you are marrying a banana trunk. Because nobody really witnessed your marriage, nobody really was there who can attest that you are married. But if the man will abandon the woman, then he has the obligation to pay for not to be sanctioned for disrespecting the dignity of woman. So I think in this case, that is why I am advocating for having this kind of customary laws will be popularized. So, for instance, in the dowry also, there is a misconception, especially to the other tribal group. They said it is like commercialized. I have an argument with one tribal man, the leader. He said, we need to give higher dowry because by the time the woman will be taken by another man, then they cannot pay. So in our customary laws, it's different because the dowry, it depends on how much the father gave to your mother. So that's the only that you can get. No, this is not really for for purposes, as they said. But what your mother received, that's the dowry also you will get from the marriage of your daughter. But if in that case, he said, we need to give higher dowry. But for us, we have different law on that. If one man will take the wife of another man, it's very expensive because he said, in other words, 60 times 2, it means a bronze gong that you will pay, and one slave you will give. So if you will convert that now, it's very expensive. The reason for having that customary laws, because if not only the wife that you take from that family, but also the mother, the children, you deprive the children to have mother. So that is the case why this kind of penalty is very high. So, for instance, for us, how important is the women? During the war or the tribal war, you should not hurt women and children. So I hope this can also be practiced now during the war, because we call it mangayaw, the warrior. It is a shame to the mangayaw if they are going to hurt women and children. So this is the customary laws that we have. There is a discussion on the age, 9 or 18. But to the indigenous peoples, for example, for us, because we don't have calendar before, but we will allow our women if she is already a responsible woman. The same true with men. So it is measured on how responsible the man, how responsible the woman, that they will be allowed to get married. So in the divorce, for instance, if the woman is having relationship with other men, especially single woman, so the single woman has responsibility for disrespecting the wife of that man that he has having relationship. So at the same time, the woman, the man, has the responsibility really for disrespecting his wife and also the parents of that girlfriend that she has. So there is also a question before that, how about if the man will beat the husband? For us, it's the same. The same sanction will be given to the man who is beating the wife. At the same time, the same sanction if the wife will beat the man. For that reason, he said, we are equal. We hurt somebody, then we need to have that kind of the same sanction. As I have said, polygamous marriage is really for men and women. And as long as they have they have common sanction. Yeah. But because there is a rule. One is you can maintain the good relationship between the family. You can afford for the dowry because the second and the third husband has a higher dowry than the first wife because the relationship of the in-laws is not the same as the first wife. So so this is our sometimes there is a misconception on this, no? But if you maltreat the second wife, there is also a big sanction on that, no? Because you should not treat the second wife as second class. No, you take that because this is part of your family. So that is why it is no longer practiced today, because it's not possible anymore. So sometimes also the rape cases is increasing in the indigenous communities. And sometimes there is an accusation that it seems this is tolerated, but it is not. Rape cases is a crime that really need the offender. Before, we really have to punish for life, in exchange for the life. But if the negotiation, is you have to marry, if the woman was raped by the boyfriend or a friend, then the settlement is to marry. Automatically, the man become a slave of that family. Because it's like, if this is the branch, you forcefully break it. So now the man has no decisions, whatever in the family affairs. So that is the case. So for us, the responsibility of men and women is the same. So if you will ask me, I'm doing this for 10 years, yes. I am really practicing this kind of settlement of the conflict. But now, as I have said, the customary laws has been changing. There are manovos now who become prostitutes. There are many children now who is exposed to abuses even among their families. So this has many reasons for this. Sometimes women are leaving their family and working outside, to support also their family, and members of the families sometimes really has this kind of tendency to abuse children. So this can be associated maybe for the pornographic or maybe for the conditions really that really expose children to become vulnerable to exploitation. So as we can say, like for instance, the concept also, as I have said, women and children, you cannot separate that. For us, in Manovo, if this is the child of other person, we call it anak. The same as we call our own children as anak. So in other words, anak is a communal responsibility of everyone. So for instance, the elder and the children, if we call our apo as apo, our apo will call us apo. In other words, we have that mutual respect, that the child and the elders has that kind of, they deserve the same respect. That is why in our culture, we believe that oppressing an orphan is really will bring curse to your family. So for us, orphans has a special treatment supposed to be. But sometimes this kind of practices is no longer evident in the community. As I have said, there are many conditions that we need to address. For instance, poverty. Sometimes other child to your family because of the poverty. And also with this kind of influences we have outside, like we have many needs already, We need television. We need, sometimes we need this. Also, drinking, no? So this is something that really erodes also the culture, the good culture, the good customary laws of the indigenous peoples. So now that I am in the NCIP, I will go back to my space and yeah, thank you. After the UN. As you have, these people who was with me in the UN, I was really trying very hard that customary law should be part of that UN draft. But it was refused all the time. Knowing also that there are customary laws that are detrimental, with other tribal groups that are detrimental to the indigenous peoples. I think the challenge there is, if we believe that women is sacred, why there is an abuse of women? So maybe there are something that really has changed in between, which this is always my challenge with other tribal groups, that you need to look back, no? The beauty of your customary laws. Maybe the customary laws that we have now is already constructed by men. Like what I have said that I read in conversation, is like to have so that the family of the woman cannot pay. So it's become a commercial, no? Because the insecurity of men, the wife will be taken away. But to the indigenous peoples, we have very specific customary laws for this. The consideration that it is not only the wife that has been taken away, but it's the mother who was taken away from their children. So for me, as now with my space, I'm trying really very hard on how these customary laws can be harmonized and can be integrated in different discussions. Perhaps these laws that you have discussed this morning, maybe you can learn also from our customary laws. That our customary law, the principles of the customary laws that made our life equal and peaceful. So I think I will end there, and if you have questions, I can discuss more. Thank you.
Thank you very much. Boy Era is the commissioner for Central Mindanao of the National Commission on Indigenous Peoples, 2 months into the job, and already is pushing for the title of 3 ancestral domains. Yes, later we will have the line of questions. So thank you. You may take a breather. Our next sharer is someone who is familiar already, especially from the previous session. She has been introduced and reintroduced a number of times. But foremost of the halo effect of such introductions, she is a human rights advocate, especially in the field of women's rights, and is also maintaining a very cordial relationship with Mindanao's peoples, and would like to be involved more when we have this context or this reality of legal pluralism in Mindanao with the BBL and other customary laws that will evolve in this setting in Mindanao. So she's also a daughter of Mindanao, adopted daughter, considering that she considers Davao as her second home. I'm not sure if she will share that aspect of her life, but shall we welcome Attorney Evelyn Ursua.
The halo effect. Thank you, Bing. Good afternoon, magandang hapon, mayong buntag. So my role, I'm the last speaker. There's one more. All right. So I thought they want to end the session already. So my role here is to share a research initiative which of the UN Women, which is a regional research initiative, and coming from the previous discussion on the practice of customary law, I think this will in a way frame the call to maybe to use the positive aspects of customary law. So understanding legal pluralism or understanding women's access to justice in plural legal systems in Southeast Asia. This is a research project initiated and funded by the UN Women. And okay, the countries that are participating in this project are 8. And the Philippines is one of the 8 countries, focuses on Southeast Asia. There's a guidance paper that was prepared for this research initiative, and the guidance paper has been circulated. It has been commented on. Actually, the latest draft integrates the comments from 2 workshops held, one in Bangkok and the other held here in the Philippines, which was a national workshop. To comment on the paper. And the paper has this is the structure of the paper. I will not discuss all the parts. I will simply focus on the major points that I think would be relevant to this national workshop and perhaps would help in the discussion tomorrow on how to move forward. So the previous discussion was all about really legal pluralism. What was described was the practice of customary law within a particular community, and it's happening within the state, and that law is not of the state. So what was being described earlier by Boy was actually legal pluralism. And the premise of this research initiative is that there are plural legal systems, or there are plural legal systems in Southeast Asia, including the Philippines, specifically in the multi-ethnic, multicultural societies, that the plural legal systems in Southeast Asia have been shaped by colonization, when layers and layers of legal orders came about, partly because of colonization. And that these plurality of laws or legal systems have survived the unitary state order in the post-colonial period. Okay, just to clarify what we mean by legal pluralism or plural legal system, in the guidance paper, we focused on several definitions. One, a limited definition, which is focused only on what we call the state legal pluralisms. Very limited. And you can say that when we refer to state legal pluralism, we refer to different bodies of state law. So all the laws come from the state, and the different bodies of state law apply to different groups of the population within the state, depending on their ethnicity, religion, nationality, or geography. So you have a very good example of CMPL, a law that applies only to Muslims. You have the family code, which applies only to non-Muslims. And that is legal pluralism for you. And both are state laws, but they apply to different groups of people. But we also recognize that this concept of legal pluralism, which is state, is limited. There are other laws, other legal orders, or other legal systems that are not from the state or not of the state. And so we have a broad also meaning of legal pluralism, which covers legal orders, laws, mechanisms that go beyond the mechanisms that are created by the state. And so broadly speaking, what Boy was describing is legal pluralism in a broad sense. Okay, so we mean here this broad meaning of legal pluralism, that there are legal orders that are complementary to, conflicting, or sometimes overlapping with the state legal order. So you have your customary, indigenous, religious legal orders that have not been incorporated nor sanctioned or recognized by the official legal system as an example. Okay. So when we say legal pluralism, we just describe a social reality. It's happening, it exists. And the social reality is this, that there are some groups or communities that have their own laws, and those laws may not be state law, and the enforcement mechanisms may not be of the state or part of the official legal system, as described earlier. We have examples in the different countries of Southeast Asia. For example, in Lao PDR, the customary practices of ethnic groups remain a crucial source of law for many people, but there is no policy from the state on how to deal with these customary practices. In Indonesia, for example, the state recognizes different laws regulating marriage and divorce for each of the 6 official religions. And more particularly for the Philippines, you have these examples of legal pluralism or plurality of laws. I already cited the first one. You have a family code, you have a Muslim code for Muslims. In the Cordilleras of the Philippines, you have community members following both customary law and state law. For example, in murder cases, as in the national workshop held last August, one of the participants from the Cordilleras described how they would apply both customary law and state law to murder cases. That's for compensation and imprisonment. In Islamized indigenous peoples in the Philippines, I think it was the participants from Mindanao in the national workshop describe how ADAT and at the same time CMPL are followed in the communities. In the Maranaos, among the Maranaos and Tausugs of Mindanao, you have child marriage, you have kidnapping of women for marriage, you have forced marriage. And these are socially accepted or socially tolerated practices, part of the cultural practices of those communities. And you can say that those practices are part of legal pluralism in the Philippines. You have also the plurality of mechanisms in the Philippines. Examples are the state mechanisms. At the same time, you have the state mechanisms but religious-based. So the Sharia courts are state mechanisms, but they are religious-based. And you have indigenous or customary mechanisms. And I'm sure those from Mindanao can identify the examples stated there. You have also the reality that even as that state and non-state mechanisms actually coexist and interface in the communities. And they function side by side, they cooperate, they interact, sometimes they borrow norms from each other. And this is one of the dimensions that the research wants to look into, the interface, the cooperation between the state and non-state. So in the national workshop held in August, there was a description of how the NCIP cooperated with the local, I think the local leaders to settle a conflict. I think it was a murder case. I was right, murder case. And then they filed a motion. I think the mediators filed a motion for the case to be suspended, and then the case was settled outside of the court. The settlement was submitted to the court by the NCIP, and the court approved it and dismissed the case. So this is a clear example of interface between a state mechanism and a non-state mechanism settling a conflict. All right. In the guidance paper that was prepared for this research initiative, the categories of mechanisms that are described there are state, non-state, and there's the third one, quasi-state. But we also recognize that these categories are not neat. They may overlap, sometimes the boundaries are blurred. And we have this spectrum of relations that are possible between the state and the non-state. So it may be that the state mechanism is not state recognized, or rather the non-state mechanism is not state recognized and ignored, not state recognized but tolerated, state recognized but unregulated, state recognized and regulated, or state integrated as part of the formal justice system, which is the case of the Sharia courts in the Philippines. And sometimes, because of the spectrum of relations, you might have heard of the labels formal, informal mechanisms, because of the formality, informality relations that are part of this spectrum. All right. The second premise of this research initiative is, in the plural legal systems of Southeast Asia, systemic violations of women's human rights occur. And because of this, there's a need to address this reality. The third premise is state justice institutions do not adequately respond to violations of women's human rights. We have state mechanisms, yes, but with those state mechanisms do not, and sometimes they do, but maybe many times they don't respond adequately to the violations. And there are many reasons for this. Of course, you know already, sometimes there are discriminatory laws. Sometimes the laws do not recognize the rights of women. Sometimes the remedies are ineffective, inappropriate. Sometimes there are no remedies. And as some of you pointed out earlier, there are social and institutional barriers to accessing the remedies. So for example, the high cost of litigation, the lack of lawyers, the lack of social services, the unfamiliar language of the process, the geographic distance, or even the discriminatory attitudes of law enforcers. Those are some of the barriers that prevent women from accessing justice. And then we have to recognize that legal pluralism itself adds a different dimension or another dimension to the failure of the state justice mechanisms to respond appropriately. So an example would be, we recognize that in the plurality of laws, for example, if you're talking of the CMPL, we already said earlier this morning, the CMPL has an equal rules for men and women. And that prevents the system from responding appropriately to the needs of women. When you have different rules for different people, different groups of people, most often the rules are different for women compared to the rules for men. Okay, and then another problem is when there are alternative dispute resolution mechanisms. In the Philippines, we have our Katurungang Pambarangay Law. It's required in some cases for women to go through the process. In other cases, even if it's not required, the process is done anyway. So it may be required, it may not be required, but when the alternative dispute mechanism is used, it's not appropriate all the time. Maybe inappropriate. Maybe women are forced to settle their cases instead of getting the proper relief that they deserve. So these are some of the reasons why state justice institutions do not adequately respond to women's rights violations. The fourth premise is that in some communities, women use non-state mechanisms to seek redress for human rights violations or for dispute resolution. It's a fact. Many studies already confirmed this. The previous presentation by Boy confirmed this also, that women use, in some communities, non-state justice mechanisms. And in terms of accessibility, it's recognized that usually or often those mechanisms are more accessible than state mechanisms. But we have to distinguish accessibility from effectiveness in delivering justice. So as the national workshop in August affirmed, it's accessible in terms of cost perhaps, financial cost, language, geography, users' familiarity with customary law, but it doesn't mean that women get genuine justice or real justice from those mechanisms. So that is something that the research wants to look into. All right. The paper, but I will not go into this, the guidance paper for this research initiative also discusses the global legal framework on access to justice, what international human rights law says about access to justice, and then what UN agencies, other international human rights organizations say about access to justice. Primarily, that it is a access to justice, a human right, it's a basic human right, it's a key means to defend other rights, it's an enabling right. Okay. And then, just to focus a little bit on what the UN Women, or how the UN Women looks at access to justice. There's a publication of the UN Women where it discusses the substantive concept of access to justice for women. And its concept consists of two elements, and those two elements are that it must have a women's human rights centered framework, legal framework, and it must have a gender responsive justice chain. All right, what does it mean? For the women's human rights centered legal framework, according to the UN Women, the following elements must be present. So first, you have there, there must be an end to explicit legal discrimination against women. So if it's in the law, it should be abolished. It should be repealed. Legislation should be passed that addresses gender-specific violations, traditionally considered private. The limited protection given by the law should be expanded. So if, for example, marital rape is not included in the rape law, marital rape should be included. We already have that in the Philippines. And then cultural practices that are harmful to women and girls should be prohibited. That should be part of the gender-responsive or the women's human rights centered legal framework. Next, legal protection, including social benefits, should be extended to especially vulnerable women. And those are women in the export processing zones, in domestic work, and those involved in home-based work. And then women should be given equal rights to property, part of the framework. Sexual and reproductive health and rights should be ensured. There should be funding for proper and adequate enforcement and implementation of gender-responsive legislation. There should be regular collection of data to drive proper implementation. There should be a holistic and integrated approach to designing laws. Okay. And then, according to the framework of the UN Women, the gender-responsive justice chain should include, you have 1, 2, 3, 4. The first one, justice institutions and support agencies with clear gender-responsive mandates and procedures. There should be agencies with properly trained personnel and adequate resources. There should be clear accountability procedures and sustained monitoring of implementation of laws. And there should be gender-responsive policing and judicial decision-making. So that's the substantive agenda of the UN Women for enhancing access to justice. All right. Back to the research, just to share with you the rationale of the research. I've explained this a little bit already. The first is the research recognizes the significance of non-state justice mechanisms, that they are involved in legal regulation and dispute resolution in communities. The research recognizes that sometimes the non-state justice mechanisms provide redress, but discrimination also occurs in those mechanisms. There's a need to examine both state and non-state mechanisms towards enhancing women's access to justice. Okay. And then these are the two questions that the research seeks to answer. Okay. First one, what does access to justice look like for women in the plural legal systems of Southeast Asia? So if you're going to do it in the context of the Philippines, questions would be, what does it look like in the Philippines, in the plural legal systems of the Philippines? And then how can this understanding be used to inform strategies for enhancing women's access to justice? So the research should be able to provide the data for programming to determine how access to justice may be enhanced in Southeast Asia or in the countries of Southeast Asia. The focus of the research is on state, non-state, and quasi-state legal orders or justice mechanisms. And here, we have discussed this well, a bit in the national workshop in August in Quezon City. And we have discussed the concept of well-defined communities. We said that in the research, the mechanisms should be existing in well-defined communities. And then the mechanism should be recognized and accepted as the legitimate source of law and authority for conduct, regulation, and dispute resolution by members of the community, regardless of the legal order's relation to the state. The question was raised, how do we define well-defined community? And so the Philippine workshop came up with this definition of a well-defined community. It may not be as specific as you may want it, but this is how we defined it. That when we say well-defined community, it may be according to physical territory or physical space, so the geography, the physical territory, or it may also be according to identity. So a community may be defined by religion, by culture, by ethnicity, or by sexuality, or even by political affiliation. And this is really just to allow the different research teams in Southeast Asia to decide the well-defined community that will be the focus of their research. But it may also include mobile or itinerant populations. In this regard, we were discussing in the national workshop in Quezon City, we're discussing the Badjaos, for example, as also a community, even if they may not have a territory, a physical territory to speak of. All right. And then just a set of sub-questions that may be asked in the research. Of course, the questions have to be refined at the country level, but these are the areas of inquiry. So the first is, what is access to justice? We don't assume that what the international human rights organizations or the UN Women has defined as access to justice, also the definition or the understanding of women in the communities of access to justice. You want to know what women think about access to justice. How is access to justice practiced in the communities in Southeast Asia? So according to the communities, according to the women. And I just want to share with you this paragraph that came from the national workshop in Quezon City, just to give you an idea how we discussed access to justice in the context of pursuing this research. So here, a community's concept and practice of justice may be integrally linked to the concept of mutual obligations of the members of the community, articulated in such statements as to enjoin what is good, forbid what is bad or evil, what is not shameful, or what does not put the community at risk. Justice may also be what brings peace to the community. Sometimes there may be contestations between women's individual claims for justice and community values. Women need to be empowered to engage with the community's notions and practice of justice, as well as with the construction and distilling of knowledge and their customary, indigenous, or religious tradition towards being full participants in the evolution of the norms and processes of the tradition. At the same time, it is also important to explore how collective justice is related to women's notions of justice and their struggles for their own empowerment. Constructive practices of justice should be given emphasis in the research together with discriminatory or harmful ones. The concept of restorative justice or its equivalents in the community may be explored. All right, second question or inquiry towards answering the two research questions. Are the state legal framework and justice chain gender responsive? Third, what is law in non-state legal orders? Actually, the sharing by Boy earlier reminded me of this question. Because when we speak of law, you know, the lawyers, at least the lawyers like me, think of state law. But we're now talking of law that includes non-state law. So the question is, how do we define really law to make it inclusive of the law that is considered law in the communities, other than state law. And this is a problem that is not easy to answer because, for example, one social legal scholar asked the question, where do we stop speaking of law and find ourselves simply describing social life? Everything becomes law now. If you cannot have that, you cannot find that definitional stop. Another one offers a definition that says it's a body of regularized procedures and normative standards considered justiciable in any given group, which contributes to the creation and prevention of disputes and to their settlement through an argumentative discourse coupled with the threat of force. I don't know if that is better for you. Then the third one offers a way to approach it, which he calls a non-essentialist approach to it. He says, according to Tamanaha, law is whatever people identify and treat through their social practices as law. So it means just the social practice of law. And he says that we have to look at the material activity, whatever people are doing, and the meaning that they attach to that material activity, and these two cannot be separated from each other, and that is law. So if we put it in the context of the Manuvo practice, then we have to ask what to them is law that is shown in their physical material activity, and we have to ask what is the meaning that they attribute to that activity, whether together they consider it as law. Or together it means that it is law to them. Okay. And so part of the research also is answering this question. When you say a non-state law or a non-state justice mechanism, what is law there? All right. The fourth question is, what state and non-state justice mechanisms exist in the community and how do they work? How are they linked, if at all? So here we're looking at the interface. What are women's conceptions of rights and violations? What are their experiences as users or non-users of the mechanisms? On this point, let me just explain a little bit. We know that for some acts are not considered harmful in the community, or some acts that women consider harmful are not considered harmful by others. Or women themselves don't consider certain acts as harmful. So the question of access to justice, I think, also goes back to the question of, in the first place, what is a wrong, what is a harm, such that a woman decides, I'm going to access the process of seeking redress for the harm or the violation. So what constitutes violations for women? That should be something that the paper says should be looked into in the research. What issues and problems in the community are related to access to justice? This is related more to the recognition that access to justice cannot be separated from the structural inequalities, the general community issues that exist in the community. And then the recommendations, how do we move forward? This is now the recommendations for programming. This is my last slide. It's not easy. Just some research recommendations that many came from the national workshop in Quezon City in August. And in the conduct of the research, certain considerations were proposed. The first is that always we must have sensitivity and respect for the culture and values of the community that is involved in the research. And this is very important because otherwise the research will not be successful. Okay. A second is finding commensurable values or the dynamic equivalence of human rights or areas of convergence and compatibility. The discussion here focused on the difficulty of advocating women's human rights in the context of religion and culture and traditional culture, and how, for example, to sell, for example, the standards of the Sadao in a religious community or in a very traditional community. And so the challenge is to look for the values that are commensurable to the human rights values that are addressed, or finding the dynamic equivalence of human rights, or areas of convergence and compatibility. So we don't have to use the same language, we don't have to use the same terms. We have to find what is that, if we have to be essentialist about it, or what is the core of it, so that advocacy is still possible. And then the third consideration is on the complexities of culture and the danger of using anecdotal cases to judge a particular culture. So it was emphasized that we may have data, but the data may just be anecdotal, and that data may not be able to capture the complexities of a culture, such that we cannot form generalizations. And so we should take caution in judging or in making conclusions with the anecdotal data at hand. The fourth research consideration: how are we going to treat local community experiences? Are those experiences adequate for us to make generalizations? It's possible that those local community experiences may be considered too particular or too micro, such that it's not possible to make generalizations or general conclusions about the community of study. And then in relation to that, the risk of misinterpretation, or the danger of misinterpretation, distortion, misappropriation, and fixation was also raised during the national workshop in Quezon City. When we have undocumented, we have unfixated traditions or practices, it's all of a sudden we do research, and then we document, we fix the practice on paper. And the danger there is because the researcher is involved in the interpretation. Danger, of course, is misinterpretation or the distortion. And even afterwards, the misappropriation of the data, the results of the research. And then the danger of fixation. Fixation may affect the integrity of the culture or the dynamism of it, and might have disastrous results. Anyway, so the next research consideration that was raised involves the caveat about male sources. Doing the research in a community, who are the sources of the data, and the construction of knowledge. How was knowledge constructed? Maybe the elders constructed the knowledge. Maybe that is not really coming from the entire community, but only from the elders who set the norms or define the norms for the community. So the caveat that to check the sources and to be careful about using male experts in the research. Second to the last, the marginalization of economic rights. This was a problem that was raised in the workshop in Quezon City in August. We often focus on civil and political rights when we talk of access to justice. But what about economic rights? For example, the question was raised: how do we use the mechanisms for accessing justice in order to secure economic rights, like have access to education, have access to medical services? Can we use a state mechanism or a non-state justice mechanism in order to secure economic rights? And this is, as discussed in the national workshop, is something that is often neglected, that also has to be focused on in the conduct of the research. And then lastly, women with disability. There was a very strong call for women with disability to be included, to be considered in the research, because they have very specific issues. For example, when it comes to state mechanisms, they need procedural accommodation, like interpreters, for example, for the use of the sign language. But beyond that, the question is, how do non-state justice mechanisms deal with women with disability who have grievances also? And beyond that, the institutionalized discrimination that one advocate who was present during the workshop described as institutionalized in agencies of the government, in laws, thereby depriving women with disability with personal agency, with rights, with a personality in law, to take action on their own situation. Okay, so this is from the guidance paper. If there are questions, I'll answer them later. Thank you.
Yeah. Thank you very much for the 30-minute. And we do have the perspective from Bangkok in the person of our speaker, Pimvadi Kiao Kivia. I hope I did justice or Burn. This is Burn's sharing. Yeah.
Okay, last presentation of the day. I know we're running late. So